Hi, everybody. Welcome to our ADAM webinar on clinical legal partnerships to overturn more denials. My name's Denise Wilson. I'm going to be your host today. We're going to go through some housekeeping information first, and then we'll jump into the presentation. Our presenters today come from Intersect Healthcare and Denial Research Group and AppealMasters, and without their support, we could not have brought this association to life and made it available to all of you. So thanks for joining us today, and let's go ahead and get started. Okay, just one thing, if you're not familiar with GoToWebinar, or this is the first time that you have participated in the GoToWebinar webinar, there are a couple of control panels that you should have. One on the right-hand side is there should be an opportunity for you to download handouts. So look for that gray bar that says handouts. And under the handouts, you should be able to download the PowerPoint slides for today's presentation. And we also have some additional handouts there. We have 3 sample appeal letters that we're going to look at a little bit later during the presentation today. And then we also have a matrix and a resource for you when it comes to looking for your legal representatives to help you with your denials and appeals. So you can go there and download the handouts. We also sent out emails about an hour ago with the handouts. If you didn't get them, you can download them straight from GoToWebinar. We do have CEUs today, and those are free to our ADAM members. If you're not an ADAM member, you do not get a CEU. You have to attend this live webinar for at least 50 minutes, okay, and complete the survey at the end of the webinar. Now, the survey will pop up automatically for you. You do not have to do anything. If you leave the webinar, it will pop up for you. If you wait till we're all the way at the end and we close the webinar out, it will pop up for you. Okay, you have to complete that to get a CEU. The webinar is going to go about 1 hour for content delivery. At the end of that 1 hour, our experts are going to stay on to answer questions. So we're going to do a Q&A panel for the last 30 minutes. If you're here just for the CEUs, you do not have to stay for that 30-minute Q&A. We hope you do, but that's not required for you to get your CEU. CEU certificates will be emailed to you typically within about a week. I do have to make sure you were on for 50 minutes, that you're an ADAM member, you completed the survey, and all of that good stuff to get your CEUs. We are recording this webinar. It'll be available on our website typically within a few days. You can rewatch it or send your friends and family over to watch it at www.ahdam.org. It's free. There's no CEUs for watching the recording. Okay. Also, to our disclosures that no individuals in a position to control content for this activity had any relevant financial relationships to declare. Okay, from the survey, when you do the survey for the CEUs, at the end of the survey, you'll be prompted to select your desired CEUs, and you can select more than one. Okay, so we have active, NARI, CCMC for our case managers, HEMA for our HIM professionals, and ANCC for nursing. So pick one or all that apply to you. Now, at the end of the survey, it's actually one survey, but towards the bottom of that survey, there are 12 general purpose survey questions that are posed by our sponsors. Our sponsors today created those survey questions to ask about appeal resource management. The survey is completely voluntary, so if you're filling it out for just the CEUs, you do not have to fill out the last 12 questions. If you don't care about the CEUs, you can fill out just the 12 general purpose questions, so you can fill out the whole thing. We will randomly choose one respondent amongst the surveys who do the 12 general purpose survey questions to win a donation of $500 that'll be donated in your name to the children's charity of your choice. So that's a good incentive to complete those 12 general purpose survey questions. You get in a drawing and could have a donation made to the children's hospital or charity of your choice. So please take a couple minutes to fill out those surveys when they pop up at the end. I wanted to let you know about our next webinar. which is the CDI and coding team approach to audits and denials. The best defense is a good offense. And we're going to present that on Wednesday, May 20th at 2 p.m. I put the great big long go to webinar.com registration link here, but our support team just let me know that we do also have the registration up on our ATTEM website. If you just go to our main page at www.ahdam.org, you can register there as well. You don't have to worry about putting in this great big long link at GoToWebinar. Okay, so thank you, support team, for doing that for us. Okay, a little bit more housekeeping. I do need to read through this disclaimer. The Association for Healthcare Denial and Appeal Management publishes and distributes materials on its website and during its webinars that are created by our members or invited industry subject matter experts for the benefit of all ATTEM members. ATTEM does not certify the accuracy or authority of these materials. These materials are distributed and presented as research information to be used by ATTEM members in conjunction with other research deemed necessary in the exercise of ATTEM members' independent professional judgment. ATTEM claims no liability in relation to reliance on the content of these materials. The views expressed in the materials are the views of the materials authors and do not necessarily represent the views of ATTEM. Any references are provided for informational purposes only and do not constitute endorsement of any sources. A little bit about our association. Our Association for Healthcare Denial and Appeal Management, we're coming up on our first year anniversary. I'm very excited about that, coming up later this month. We are the nation's only association dedicated to healthcare denial and appeal management. And our mission is to help support those of you who are working in appeals, denials and appeals through healthcare payers. We want to promote the work that you do, provide resources to you, provide a community where we can collaborate and learn from each other. And our vision is to create an even playing field where patients and healthcare providers can be successful in persuading medical insurers to make proper payment decisions. Okay, so our presenters today, and I'm going to let each one introduce themselves. Dr. Kendall Smith, who is our Chief Physician Advisor at Denial Research Group and is also an advisory board member at ATTEM.
Hi, good afternoon, everyone. I'm a hospitalist by training, a background in clinical documentation improvement, was the medical director at Cleveland Clinic, the utilization review for about a decade before joining Intersect Healthcare and AppealMasters in 2012, 2013, going on 8 or 9 years. I have a tremendous love of denials, research, and legal argument, as we'll explore today, and look forward to sharing our cumulative knowledge with you over the course of the afternoon.
Okay, our next presenter is Brian McGraw, and he's president at Intersect Healthcare and Denial Research Group. He's also on the board of directors of our ATTEM Association.
Good afternoon, everybody. This is Brian McGraw, and I've had the privilege of serving hospitals since 2004. I was thinking as I was on my exercise walk today, my first appearance in front of a judge was in 2005. It was a Medicare probe audit, HBO therapy denials, and I learned early on, this is back when they did Medicare hearings at the Social Security office, that a picture is worth 1,000 words. All I had to do in that very first case was show them that toe wound, and the judge passed all 5 cases. So in that case, a picture was worth about $14,000 back to that small West Virginia hospital. So we are advocates for hospitals, and I think that you'll learn today some of the tactics that we've had to really change as the payers have begun to move the cheese. We have with us also Bill Haynes, who's our managing attorney here at Denial Research Group. He's a big part of the clinical legal unit here. And so thanks, Bill, for being online and helping us. We look forward to serving you.
Okay, and then I am Denise Wilson, and I'm Senior Vice President at Denial Research Group and AppealMasters. I'm also President of ADAM. So I've been in healthcare basically my entire adult career, and I've been in denial and appeal management for the last 15 years. And basically do a lot of education these days, a lot of making sure that we have resources available to you at ADAM, that we're meeting the needs of our membership, and doing education for hospitals around the country on denial and appeal management. Okay, so I'm going to turn it over to our first presenter, Dr. Kendall Smith. Let me give you, there you go. Let me give you control.
Okay, fingers crossed. Technology is always a leap, especially when you're working remotely. So we'll see how this goes.
Yeah.
So one of the driving forces that's become apparent over the past couple of years is there's been a movement away from what we call traditional insurance, Medicare, traditional Medicaid, and a march towards patients being insured under Medicare Advantage plans, for example. This is a chart going back to 1998 on the left, and then looking forward 4 years from now on the right, where you see an almost 70% enrollment rate or penetration rate with Medicare Advantage members. So what this tells us is the playing field, as Brian had mentioned earlier on, the cheese keeps getting moved, and this is one of the driving forces behind that phenomenon. We're having the concentration of patients, as we'll see in the next slide, hopefully, into fewer and fewer insurance companies. So at the end of the day, what we're left with are a small number of insurance companies that are basically dictating the care that's being delivered to more and more patients. And with that power comes significant challenges that we'll explore, that eventually led to the creation of the clinical legal unit. The groundwork for the clinical legal unit, I think, in my mind, thinking backwards, and Brian, I'll ask you what your thoughts are, go back to about October 30th of 2014, a significant date for those of you that have been in appeals since over the last 8 to 10 years. That's when the RAC, Recovery Audit Contractors, and CMS reached a settlement offer with hospitals. And at that point in time, our business shifted as well. We were traditionally focused on RAC type appeals. With that came a certain level of comfort and certainty, because the rules governing those appeals were set forth by CMS, by the administrative law judge program, and we knew what to expect and how to approach and how to deal with those. October 30th, 2014 changed and the environment greatly. We had a lot of auditors that were doing RAC appeals and audits at that point, who then started out and started to sell their services and abilities to insurers. United Healthcare, Optum, Cotiviti are names that you might recognize, that are now working on the private insurer side of the fence. The rules, though, governing audits and denials did not transfer over from the ALJ program. They were operating under a completely different set of rules and denials, and with that, tactics had to change. You know, Brian, you run the company for 20 plus years, and curious as to your thoughts on that date and the shakeup in the industry at that point.
Well, it's interesting. I just read an article in Modern Healthcare that between 2014 and 2019, hospitals' Medicare billing practices by the OIG, this is a report by the OIG, suggested upcoding, so that the severity codes increased nearly 20% from fiscal 2014, when the RAC program was really tamped down, through fiscal 2019. All this tells me is that the OIG is now looking harder and harder at hospitals using these severity indices 20% of the time. The aha moment to me with Medicare Advantage came when I spoke with a physician by the name of Roy Baker down in South Carolina, and he made me realize that Medicare Advantage patients have all of the rights that providers used to have in the ALJ program. However, you had to really take on that patient right of appeal in order to move that further. And so, my concern has always been that this is the privatization of Medicare, and that all of a sudden those traditional Medicare levels of appeal that we used to have don't exist any longer. And so they are really oftentimes with organizations like United Healthcare, Cigna, you're one and done unless you get that patient right of appeal. So we'll talk about that later on. We just think this is a very telling statistic that Medicare has gone private, and we're really at the beck and call of these private insurance companies.
And at the same time, you're seeing more and more employees and workers that are covered by employee-sponsored or self-funded plans. A lot of times folks hear the word self-funded plan, they tend to assume that that's an insurance policy that someone's paying for out of their own pocket. These are actually what are known as ERISA governed plans. And ERISA is, we'll talk about a little bit later in this discussion, brings with it a completely different playing field and completely different set of rules than comes with traditional insurance. As Brian had just mentioned, one of the keys that we're going to talk about over and over today is obtaining the patient's rights of appeal so that you're representing the patient or appealing in the patient's shoes. It creates a very different playing field than if you're appealing on behalf of the provider or the hospital entity. So to give you an idea, and these statistics go back 5 years, so I realize the slide may be a bit dated to those of you that are looking at the source, but I can tell you that this information has not been updated in the last 4 years. What I can assure you, though, is that the numbers have consistently gotten bigger, gotten larger. 2016, 2017, the annual value of insurance claims submitted by hospitals for patient care and services exceeded $3 trillion. Insurer denial rate averaged about 9 to 10%. Anecdotally, our experience is that denial rate is going up in certain parts of the country at an even greater rate. There's certainly targeted diagnoses like sepsis 3, that are driving the denial rate up at an even faster clip. The average hospital cost in 2016 for preventable insurance denials amounted to about $5 million for the average community hospital, about 150, 160 beds. Gives you an idea of the size of this industry, and this is the source for this information is from Change Healthcare, which is cited at the bottom. This is an enormous industry, and there's an enormous amount at risk, an enormous amount at play, and there's an enormous amount for us to work to recover. One of the things that changed after 2014, and this started to accelerate into 2015, 16, and 17, is that as a chief physician advisor, I noticed that our traditional appeal strategies weren't succeeding to the degree that they were in years prior. We went back, Denise, myself, Brian, looked at the quality of our appeals and found that they were actually getting better and better. And we started to notice that it's disconnect between the quality of the clinical appeal, and clinical appeal being the key word here, and our overturn rates. And it almost seemed as though the insurers were not listening to reason. They weren't giving fair consideration to the clinical arguments that we were putting forward, citing why the care was necessary, appropriate, met reasonable standards of care. And quite often we would even get letters back where it was apparent that despite all the work we had put into an appeal, the appeal hadn't even been considered. There's nothing more frustrating and insulting than putting your heart and soul into trying to overturn care, putting a really well thought out argument together, and then getting back a letter from an insurer that makes it very apparent that the letter never even got read. So what we started to focus on a few years back were some additional strategies. Raise the question of what else is out there beyond appealing on a clinical basis that we can use or cite or bring into the fray? What additional tools can we identify to get the insurer's attention? And if we can't get the insurer's attention, are there additional parties floating around in the universe that have a vested interest in making sure that these denials are dealt with fairly? And the answer to all of those statements or questions was yes, yes, and yes. There were additional things that could be done. It turns out there are additional strategies that can be brought to bear on dealing with denials. And as we'll learn shortly, there are certainly additional organizations, third parties, which have very, very vested interest in making sure that the denials and the hard work that you're doing are dealt with in a fair manner. One of the things that Brian and I bounced back and forth about over the past couple years was the idea that certain portions of federal law dictated the provision of care. So Title 42, as it turns out, contains a lot of language related to Medicaid, Medicare Advantage. Bill, what other types of things would you find under Title 42? Just putting you on the spot for a second.
There's a great deal under Title 42, but we found the most use out of the requirements for the coverage of emergency care, particularly because those requirements are a bit more detailed and have more language that's useful to enforce those requirements, particularly in terms of giving deference to the treating physician. Which has been invaluable when dealing with Medicare Advantage and Medicaid cases.
So I would echo what Bill said greatly, and this was our first aha moment and sort of breakthrough that led to the decision and the realization that we really needed a legal arm to what we were doing, that just depending on a clinical argument going forward was going to, in all likelihood, result in less successful outcomes than if we started to understand and bring to bear all of the rights that are vested under statutes, both at the state and federal level. Title 42, as Bill had mentioned, is a literal gold mine of information, which we'll explore shortly. Some examples of what you'll find contained within Title 42 of the CFR. Title 42 CFR, some language related to Medicare Advantage plans. This particular section governs what's known as emergency and urgently needed services and maintenance and post-stabilization care services. And one of the interesting things we found in looking at both the language and the laws related to Medicare Advantage plans and managed Medicaid plans is that there's a tremendous, I wouldn't say power, but there's a tremendous deference to allow the hospital to provide care to the patient without the interference of the insurer. And the way these laws are set up, they're set up deliberately so that a patient who has a true medical emergency, and a medical emergency is defined under EMTALA. Bill, I'll defer to you just to describe EMTALA if you could to folks.
Yes, EMTALA is the basis for the emergency treatment definitions you actually find in all of these statutes, but they tend to use the same language. And EMTALA is the statute that is a regulation of hospitals that forces them to give treatment for emergency care in order to prevent patient dumping, to prevent them from either just not treating patients or to transfer them improperly to other hospitals when they find out they don't have insurance. But from that came primarily the definition of the prudent layperson, which is the definition used in many of these statutes, almost all of them. And the prudent layperson is the idea that it's an emergency medical condition if the prudent layperson, not a doctor, not somebody with medical knowledge, just a prudent layperson looking reasonably at their symptoms, believes that they have or have something that might constitute an emergency medical condition. So that's the idea.
Okay, and once what that says in terms of hospital behavior and what the hospital's responsibility to the insurers are is once a patient shows up in an emergency department with a perceived emergency, say they're having chest pain or they have a fever and a productive cough and are diagnosed with pneumonia, the hospital can go ahead and treat that patient under both of these statutes without contacting the insurer for authorization. And that treatment can extend beyond the emergency room to what's called stabilization. So if you take a patient who has pneumonia that you admit as an inpatient for stabilizing treatments, intravenous antibiotics, for example, that whole period of emergency room care through stabilization as an inpatient, there is no need to contact the insurer to get authorization, because to do so would be to delay that patient's care and subject them to needless risk. The language under the managed Medicaid plans actually differs even further, and it says it's up to the attending physician, not the medical director, for the insurer to determine when the patient is stable. So this is a very powerful portion of federal law. I encourage you all, when you need some bedtime reading, to go onto Google and take a deeper look at some of this. It will put you to sleep, but it may give you some aha moments that'll keep you up late in the night as you get excited about learning what else you can bring to bear into this. Denise, you're going to pull up some of these here?
Yeah, let me go ahead and share the other screen where we have some examples of some appeal letters. There we go.
Let me see if I have, perfect. One of the greatest, I think, realizations that I had as a clinician and appeal writer in the past year and a half of working with our legal colleagues was the ability to go to them when we got stuck or we realized we were up against a brick wall, and we needed a way to navigate around something that previously we might have not been able to do so well. COVID, for example, has created or led to unprecedented disruptions, both in hospital operations and insurer operations. And we remember the disruptions in the U.S. mail service earlier this year. The insurers were really quick to point to COVID as a justifiable reason to delay payment, to delay performance under their contracts, et cetera. Bill and the rest of the attorneys that work in the legal unit were able to develop for us a good cause argument that we've included with a lot of our denials since early last year, giving us a longer time period to respond. Quite often we were finding denials were showing up in the mailbox 90, 100, and 120 days past the time to respond to the insurer for various reasons. So we were able to develop a good cause argument in sending these back to the insurer, saying that this was beyond our control and you need to give full and fair consideration to what's contained in these letters. It's been tremendously useful, and we'll share these with you going on. So what we'll typically do in these letters now is to start with a general discussion of the relationship between the hospital and the insurer, and describe or put the insurer on notice as to what types of rules or laws are governing this relationship. To make that, the goal of these letters are really to make the insurer aware the hospital is fully aware of its rights, it's fully aware of the insurer's obligations, and we expect this to be dealt with in a fair manner. And if it's not dealt in with what we feel is a fair manner, that we intend to escalate this or bring this to the attention of relevant parties outside of this dispute. We'll talk about federal, we'll talk about state, and we'll talk about regulatory bodies that you can involve in your disputes in just a moment. A lot of footnotes. Some of this is blacked out because it's state law or redacted due to HIPAA. But basically, gives you a sense of what these letters look like. We'll talk about and put the insurer on notice of the complexity of the care that the patient was receiving. We'll go through a clinical justification, and what we found is that as we shifted to a more clinical legal argument, that our traditional clinical argument that might be 3, 4, or 5 pages long has now become much shorter and much more concise. We're just getting the facts, ma'am, as they used to say. What, Brian, what show was that? Just the fact.
Dragnet.
Dragnet, there you go. I was going to say Get Smart, but I lost that one. So
yeah.
But we really focus from a clinical standpoint on just the facts. We want to establish the reason the patient was there. We want to establish why he or she needed the care that was provided. And we want to establish that the insurer had a reasonable responsibility to provide care, that the hospital had a reasonable expectation to get paid for this. One of the things that is driven me to the brink of frustration and headbanging, and I think Bill and Brian can both echo this because they hear this from me quite often, is what we perceive as a deliberate, that's my opinion, but let's just call it a misuse of MCG and interqual. Time and time again, you'll get denial letters where either the wrong guideline has been used, whether that's by accident or intent, I don't know. You see it quite often with such regularity from specific insurers, you've got to wonder sometimes. But it also appears that MCG and interqual are being applied in an inflexible way. MCG actually comes out in its in the beginning of its documents and says specifically that these are not inflexible guidelines, that you have to give some deference to the treating and attending physician. You have to consider complications and comorbidities. Brian, you're waving a paper.
Move on, Kendall. We got it. We're 2:35.
Gotcha. So I love something I could talk about for far too long. So
right.
You can see the citations through here. All of these came about through the legal department. I'll give you one more real quickly. Same sort of format. We'll talk about NCQA guidelines shortly and what these mean. But the basic goal of a clinical legal approach is to bring attention to the insurer that we know what the rules of the game are. We're putting them on notice about it, and we're going to carry this forward if we can't reach an agreement as to what was done here. Denise, can you go back to the other slide so I can get the lead up here? Obviously,
and let me just say as well, these are the part of the handouts that you can either download from the presentation here today from within GoToWebinar. We also sent them out via email prior to all the registrants prior to the session. So you do have all of those letters, the 3 letters that Kendall had pulled up. I think you just got through 2 of them, but there's 3 in the handout.
Can you get back to those slides for me, Denise? I've got.
Yeah, you should. Let me make sure you've got control here. Okay. Now, can you move your slide?
No, I don't have control. I may have to let you, just in the interest of time, go through the next couple ones if you could.
Sure.
Okay. Yep, I do.
You do have control?
Yep, I do again. Okay. Thanks. So the goal of all of this, and I'll speed things up so we can get Brian and his expertise into the last half of this, is to escalate these cases, these disputes outside the court of the payer's opinion and do it as quickly as possible. We put insurers on notice from the get-go that if there's not a favorable finding on the appeal, that we will go outside the court of the payer's opinion. First and foremost, and I'm going to let Brian talk a bit more about this in depth, or the patient's rights of appeal is a way to escalate outside the court of the payer's opinion as quickly as possible. The reason you want to get out of the court of payer's opinion as quickly as possible is to get paid as quickly as possible. Quite often doing so involves the patient's rights of appeal. Early on, we involve the State Department of Insurance for the hospital that we're representing. Your State Department Insurance you can find from Google and online. We've developed some phenomenal relationships with state DOI agents. We're actually exchanging emails and phone calls on a regular basis. They've become, quite surprisingly, I thought it'd be a huge bureaucracy, but they become phenomenal advocates for what we're doing and intervening in these disputes. Insurance companies are licensed by the state. The state DOI will investigate complaints related to unfair claims handling. And as I said, it's a tremendous, tremendous resource. Every state will have a state DOI that you can reach out to. There are some types of insurance that they can't get involved in, ERISA claims, for example. But a majority of the insurers you're going to be dealing with, they will intervene and they will try to resolve these things amicably. NCQA and URAC are to insurers, as the Joint Commission, or TJC, are to hospitals. They accredit insurers. So to participate in CMS programs, Medicare Advantage, state Medicaid programs, an insurer must be certified by either NCQA or URAC. NCQA and URAC both have very specific rules, requirements related to utilization review that insurers must follow in handling a denial. And if you are seeing things like misapplication of MCG, you're sensing that your letters aren't being read, appealing to or involving or telegraphing to the insurer that you're going to bring NCQA or URAC into this will often get their attention. I've actually had a couple of insurers reach back out to me very quickly when I mentioned that if we couldn't resolve this, NCQA was going to be bought into it, and say that's not necessary. Let's see what we can do internally to resolve this. We don't need to talk to NCQA. So again, a very powerful agency. And Brian, I'm gonna hand it off.
I think that brings up our poll. So we're going to do a series of poll questions. I have 6 of them. I'm just going to leave them up for about 15 or 20 seconds each. Ask you guys some questions about what you're seeing at your organization. Then we're going to reveal the results of the polls at the end when we start the Q&A session at the end of the presentation today. So I'm going to launch our first question. Okay, are you currently incorporating legal protections in your clinical appeals? Never, sometimes, often, or every time? Also, if you guys have any questions for our panelists, be sure to enter those in the questions box, and we will answer those after we look at the poll results during the Q&A session. Okay, I'm going to close this one. We'll go on to our next one. Okay, how often are you escalating to external review, independent review organizations, or dispute resolution? Never, sometimes, often, or every time? All right, I'm going to close this one. Let's go to the next one. Okay, have you submitted complaints to your State Department of Insurance on payer claim behavior? Again, never, sometimes, often, every time. I think we're going to get some really interesting results on some of this. Okay, I'm going to close that one. Let's go on to the next one. Do you agree that legal protection should be partnered with clinical evidence-based standards in your clinical appeal processes? Sorry, my box is so small on my screen, I have to get really close to read the question. And this time you get disagree, sometimes, or fully agree. This really has become the new standard of, ensuring that we've got those legal arguments and those legal protections in there. It's no longer good enough to just argue the medical necessity of cases. And we've really learned that through our dealings with managed Medicare and other commercial payers. Okay, we're going to close that one out. Got two more. Okay, let's launch this one. As an appeal specialist, I have access to our payer contract language regarding dispute resolution. No, some, or full access. All right. And then our last question. Have you filed commercial payer appeals, including Medicare Advantage plans, as the authorized representative for a patient? Never, sometimes, often, or always. So this is something that I know Brian and Kendall and myself even have been advocating for. And as Brian said, talking to Phil Baker at South Carolina, he's kind of the expert on doing that, and he's kind of taught us a little bit about some of his techniques, and really interested to see how many folks out there are actually using this methodology. Okay, I'm going to close that. Like I said, we will go over the poll results during the Q&A session. I'm going to go ahead and pass control over to Brian and let him continue with the presentation today.
Thank you, Denise. And Denise, I would ask you to put a stopwatch on me, 2 minutes a slide. All right. Great. So defining the clinical legal partnership, and we call it a partnership because we really felt that one of the only avenues left open to us as advocates for hospitals in their right to be paid is we needed to bring to bear their protections, their entitled rights. And so the partnership is not a doctor and a lawyer. However, sometimes it happens, but essentially we're really trying to combine the clinical information with the legal information within the body of the appeal, and really telegraphing to the payer that it's our intent to go all the way. We understand the law, we understand our rights, and we're going to exercise them. And so it's not personal, it's only business. And so one of the big challenges has been dealing with the managed care departments and managed care directors over the last few years and saying, well, look, we really don't want to upset the payer. I have to tell you all, I think we're past that. I think we're now at the point in post-COVID and really the reckoning that we've received in the last year and a half is that we have to fight for every penny. And anything we can do, that's an important thing. As Kendall was saying, we've seen egregious, ridiculous denials that are upheld. And it's just, for those of us that really support hospitals, that work in the back office, we want our money. And I think that we have to bring these payer behaviors, this malfeasance, this abuse, to the attention of the governing bodies and the accrediting agencies. And not in a malicious way, but the facts are the facts. And so Well-defined clinical arguments have to be combined with your supporting legal protections. And oftentimes, what we've learned is that patients have greater legal protections than providers. How do we get there? Get disciplined in your appeal department. Make sure you have intent. Follow through. Make sure that you help set up this legal side of writing clinical appeal, whether it's clinical validation or medical necessity. There is support out there. Okay. I'm going to say it was under 2 minutes because Denise didn't say anything to me. And how do you define and develop your clinical legal approach? So we believe that these should be applied at the very outset of patient engagement. That means at the admission registration area, you need an authorized registration or authorized representative form signed by that patient. No different than they're signing any consent to treat. So we've worked with other organizations and counseled them and worked with them to develop forms that incorporate and include appeal rights on behalf of the patient within that consent to treat. Who does legal research? Well, we know that it's not necessarily the nurses that are going to go out and do it, but you have the capability to go out and hire very smart young people or even very smart older people that can do legal research on your behalf. You have to identify and apply those legal protections. There's a lot of them. The problem, oops, I didn't go. Denise, what are you doing?
I didn't do it.
Well, okay. There we go. Good. Who do I involve? Well, clearly you want to involve your managed care department because they have the managed care contract. You need to understand what's in that agreement and what they've agreed to, whether it's abiding by the payer's medical policies, abiding by certain time frames, certain levels of appeal. But what we've often found is that there's information missing from managed care agreements. Are they limiting the number of audits that they can do? Are they using e-communication and electronically delivering us information related to these denials? No, everything's by snail mail. How much more work is it going to be to me, an appeal writer, who is looking to locate some legal language or what we call snippets to incorporate into my clinical appeal? How much of an investment are we willing to make? And frankly, when I think about how over the past couple of years we've seen overturns go down and decision timeframes go up, we realize the road has been laid out for us. If we don't get out and make an investment now in research and time and adding the right staff and information to these appeals, we're in a world of trouble. What we did at our organization, and I know this is very small, I'm sure it's difficult for all of you to see this, but we did send a handout as well, is we developed a clinical legal decision matrix. We've sent this out as a handout. Certainly feel free to call us on this. But really what it does is it takes the scenario that the nurse or physician is faced with on the clinical side and then adds in the separate arguments specifically that they can apply. And so Bill will tell you, I'm a stickler for developing by state legal snippets that apply to each one of these particular legal protections, whether it's statutory, i.e. state or federal. So this is possible. I'm pretty sure that a lot of you have developed appeal matrices in your organizations and now have an appeal matrix, how many levels, where it's got to go. Well, this is another tool that you can use. It's simply a job aid that good appeal clinicians and dedicated appeal specialists can use to select the right legal argument that would apply in their particular scenario. That's the second page of it. So again, we sent that as a handout. Certainly feel free to contact any of us to assist. If you want some help developing that, we're certainly willing to discuss how we went about it. How do we develop our legal unit? Well, I've been using health law legal interns since 2009. And essentially, I was trying to do that type of legal research using interns at first. There are health law certificate programs for law schools around the country. we think that's an option, seeking those particular candidates. Consider in your own organization, are there legal interns there? Maybe in risk management, maybe in the legal department, where you can get some legal research done on Title 42, on statutory protections within California, within Texas, within Kansas. Make sure you do that. We think that there are plenty of paralegals out there that would be very, very interested in advocating for hospitals. I think we've all seen across the nation how hospitals have responded in this pandemic, how the frontline workers have responded. And I have to tell you, nothing gets my dander up more than we're still fighting these insurance companies after seeing our, let's call our partners, give it up for the nation. And so it's really important that we all jump in and help. We did think, and we've hired recently, recent law school graduates, and mainly because they have some idealistic viewpoints on public policy, on social issues, and on justice. And I think that we're very, very blessed to have some excellent staff, not only doing research, but applying these snippets in some of our appeals that we send out on behalf of these clients. I want to talk briefly about dispute resolution and dispute resolution workflow. I was trying to say it earlier. I didn't want to interrupt Kendall, but if anything that Denise and I and Kendall learned from the RAC process, and we did thousands and thousands, tens of thousands of RAC appeals, was that you really didn't get a fair shake until you got to the ALJ. And that's where I coined the term, you're not going to get a fair shake until you're outside of the court of the payer's opinion. You're just not. And you can whack me on the head with a baseball bat. I'm still not going to believe it. And so we really believe that you just have to, this dispute resolution process is in almost every managed care contract. And as far as we're concerned here, we just consider it another step in the appeal process. There is internal grievance, and that's where you're allowed to go to. And then you have to notify them that you're going to take advantage of whatever dispute resolution processes are out there. One of the issues, if you look in your contract, is how many arbitration experts have they decided that need to be involved? Well, we have some clients that require, or some payers require 3 arbiters. Well, boy, that drives up the cost of an arbitration. But you really want to find out what are the costs of external review, mediation, and arbitration by contract before you start to pull that trigger, right? There are certain things you can do, like grouping cases together to build a pile of arbitration cases before you get out there. And so there's some strategies you'll learn about and talk about. Workflow is crucial. It's not as complicated as you might think. It's actually quite a repetitive process. And so once you set up a process-driven workflow and you're intending on invoking dispute resolution, it's very replicable. And you can even make parts of it highly automated. Like in our dispute resolution process, we always send a complaint to the insurance company, the insurance commissioner. It's baked in. And so if they've upheld something at the internal grievance level we felt certainly should have been overturned, we're going to file a complaint. And to me, that's baked into the process. And so that's part of what we want to do. Now, like the ALJ, hospitals may represent themselves, quote, pro se, and that means the hospital can represent itself in the arbitration. And so don't feel that you have to have an attorney unless it's required by law in your state. But really, a good appeal specialist, a good physician advisor, and maybe some backup legal researcher, or if you have, again, a young attorney on staff, maybe that will help. But really, that's part of the workflow. It's moving forward. Good. Just a flow chart, right? Simple flow chart. Once you're there are certain things. You do a legal review. You review the supporting documentation, recommend, don't recommend. And down at the bottom here, you'll see set aside for group arbitration, request mediation, or demand arbitration. So you can really, if you need to set up a pile of cases, you can do that based on how much it costs you to proceed with dispute resolution. And these are the different pathways. Again, not terribly complicated, but really just a flowchart exercise, no different than anything else in all your process flows as they relate to complex AR resolution. We've been waiting to get to this, and I think this is important. And the purpose of those first two slides in the presentation was to show, gosh, look how much Medicare Advantage is going up. And then, gosh, look how much self-funded plans or employer-based plans are going up. Both of these plan types, you'll benefit so much greater if you have really put yourself in the shoes of the patients. You can't just go the old, well, they can assign their benefits. It really has to be very specific about being an authorized representative for their appeal rights. And so perfecting that is really important, especially with those two, monstrously growing plan types. Admission and registration, the very best time to get it. I do think it's important. I'd recommend that your top 10 payer authorized rep forms be electronic, and go ahead, put them right in your Epic system, put them right in Cerner, put them right in the UR systems, someplace where they can get to. The other suggestion, and I heard this a few weeks ago, was now that you have to present a Moon letter in for outpatient observation or observation patients that are Medicare traditional or Medicare managed, put it right in there. I mean, for goodness sakes, we should be advocating, because there's a problem with patients who, when they get that observation notice, they're put on notice, but they probably don't realize that they're at greater financial risk as an observation patient than they were as an inpatient status patient. So this is one of the things that Phil Baker and Bruce Ehrman really educated us on, is saying, look, we need to advocate for the patient at bedside. If we think they should be inpatient and the payer wants them to be observation, you need to fight for that. And you really have to have that patient sign that form so you can advocate on their behalf. It's no different than when you had the patient sign a form or had an authorized representative for your ALJ hearings.
And it's so much easier to get these things up front than it is to try to get them 6 months after discharge. So whatever processes you can work with your registration, UR, and leadership, we encourage you to try to bake that process into the registration process up front.
Yeah, I agree, Kendall. And I think that the biggest challenge is the forms committee at the hospital, right? And making sure it goes through legal review. But really, it should be baked in. When you see these two large payer types growing and denying, you recognize when you see denial letters coming to you and they're addressed really to the patient, but you get a copy because you're the provider, that's a commercial self-funded plan, right? Because it's the patient who has the rights of appeal, not you. You might get one and done. The patient has many more rights than you do. The payer's entitled rights to deny payment. They are entitled to deny. Why we get these adjustments? Because it's in the contract. It's in the provider manual, and they're applying the payer clinical policies that you've agreed to in that managed care agreement. MCG, Interqual, NCDs, LCDs, proprietary guidelines, name it. They actually have a right to deny payment. And so we have to exercise our rights as providers to using appeal rights. ERISA, this is not an easy one, okay? There's an awful lot of protections for you as the provider under the ERISA laws, and you have to dig them out. You have to apply them. And really what I suggest is that these plan types have to be rolled up almost like a financial class, because they provide the greatest financial risk to the hospital, we believe, or one of them, when it comes to non-payment or underpayment. Dispute resolution should be in every contractual agreement. And if it's there, you should use it. It's your right to use it. You want to leverage other external resources, as Kendall and I were discussing, and saying, look, you've got to have a systemized or systematic approach to pumping these things out the door and responding quickly. So we're big believers in that first paragraph. You have to telegraph your intent that we're not putting up with this. It's not we respectfully request you reconsider this. It's we completely disagree with your determination, and here's what our intentions are. So know what you can do. You know you have an appeal matrix. Build one if you don't have one, and if you don't have one, call us and we'll help you build one. Department of Labor, again, great resources out there. You want to go right out there and understand what your rights as a provider are using the Department of Labor laws. That means that all commercial plans, they're not insurance at risk. They all are employer at risk. And you have lots of protections and avenues to go down in those appeal processes. They have to conform, their policies have to conform to the Department of Labor laws. Same thing goes with Medicare Advantage. And so there are sanctions that are, if they don't play by the rules, there are sanctions you can remind them of if they don't play by the rules. One of the things you have to do is you have to start collecting the information. You can't just present willy-nilly their abuse and their malfeasance, and they're not looking at denials or appeals. You have to catalog it. You have to have the data. And so collecting and presenting that data, whether it's at a joint committee or joint operating committee or whatever, is important. Payer plan by payer, clinical, legal, appeal, content management. So this is what we suggest you put together is we do everything at the plan level. And so a self-funded plan is not a marketplace plan, is not a Medicare Advantage plan. They all have different appeal rules and different rights. And within that appeal matrix, you can really build that out and identify what are my protections, what legal information can I use by plan type, by contract as I go forward. We're a big believer in scripting it, testing it, making sure that script works, and doing it. And so step by step by step by step by step, I always ask, a process flow is nothing more than a put down on a white line paper, 1 through 10. Tell me what you're going to do. And then you go do it. And so part of it is building that into your workflow process and making sure that you follow through with it. Knowing your rights. And again, it may seem like the build out we're talking about is hard. It's hard to do. But Bill will tell you, Kendall will tell you, Denise will tell you, once you do it for your state or your facility in whatever state you're in, the federal laws don't change. It's your state laws you want to get in there. You want to make sure that you can bake them into your clinical appeal process. Once it's done, it's done. And it's a lot easier to maintain once it's done. But you have to make that investment to say, I'm going to commit to a full bore appeal process, and we think that's part of what it is. And we talk about self-advocacy and patient advocacy, but advocating for yourselves as hospitals is combined with advocating for your patients. When you step into the shoes of the patient, you know more how to do an appeal than they do, I can assure you. The good thing is they have deeper rights than you do. But when you represent them, and it's really an avenue you should consider, you're advocating for that patient, and your job will eventually be easier. My last slide, I think it's one of my last slides here. I know I'm 3 minutes over. Is that it's important to get executive buy-in. Firm resolve to get paid begins at the top. That's it. CEO, CMO, and I guarantee you, if you talk to your CEO directly, your CFO directly, they'll buy into this process. They will, because they know how much harder it is getting paid now, and how much more important it is to get these appeals out the door and to stick to it and stick to your guns. I think managed care will be a help or a hindrance. It really depends on the personality of the persons at the top of the managed care department. And if anybody's from the managed care department online, I apologize. That's an opinion. But their marching orders really have to come from the C-suite. And they all need data. Okay, they need your denial and your overturn and your payer denial data. And so making sure you have all the reports and data in front of them so they can support your decision to go full bore is important. We feel that pursuing full payment is a fiduciary responsibility. I'm sure that the board would think it is. And what we've learned is how many passionate appeal specialists there are out there. We have lots of them working for us, and really the passion is just, it's within what we do, and we all take it very seriously. And I think we should be fully supported by the C-suite and senior level managers in that effort. Denise, Q&A. This is where we can pull up the results of the poll. And then
yes, let's look at the results of the polls. We'll talk about that a little bit, and then we'll see if we have any questions that have come in. And this is our support staff back at our corporate office who helped us with this webinar today. I want to thank them for being online. And okay, so our first, let me see if I can make this a little bigger for myself to read it. So our first result from our first question was, are you currently incorporating legal protections, state, federal accrediting agencies in your clinical appeals?
Wow, 41% never.
Yeah, 44% sometimes, good.
Yeah, that's good.
I'd like to, 3%. I'd like to talk to the 3%. Say, how can we get you to help us persuade the other 80 some percent? Okay, let's go on to our next one. How often are you escalating to external review? Well, 60% sometimes.
Yeah, the never still bothers me. And there's got to be a reason behind that. I like to see every time though. We do have a client of ours that escalates every time, and but they're the only one out of a large group of clients that escalates every time.
Okay, let's look at our next one. Have you submitted complaints to your State Department of Insurance on payer claim behavior? Never and sometimes.
Hope the state DOIs are going to get a lot busier after this talk.
I hope so. It works.
It really does. It's free. It works, and they have a vested interest in making sure that people are playing fairly. So,
right.
Walk away with anything. Just remember, you got an ally in your state DOI.
Okay, next. Do you agree that legal protection should be partnered with clinical evidence-based standards in your clinical appeal process? Yes. 79% fully agree, 21% sometimes. Well, that's good. I like to see that.
Well, you kind of talked him into it, Denise, when you were doing the poll question.
Oh, did I do a little persuading?
That was not a question at all.
Yeah, it wasn't a question. That's right. Okay.
Might have persuaded them a little. All right, next one. As a appeal specialist, I have access to our payer contract language regarding dispute resolution. That's a little bit spread across the board there.
It's actually gone up. I mean, compared to the way it used to be. If you recall, for many years, we always hear from different clients that we don't have access to the contracts. We don't have access to the contracts, and which is unusual. So, but now I think there are appeal matrices being built in different organizations. So that's good.
Okay, and then our last survey question, poll question, I guess. Have you filed commercial payer appeals, including Medicare Advantage plans, as the authorized representative for a patient? 11% always.
Yeah, but 75% I would say rarely or never.
Mm-hmm.
A whole nother
well, sometimes, yeah. Sometimes, I guess, is that rarely, but I agree. At 75%. Okay. Huh.
Okay, interesting.
We have a lot of work to do. We have a lot of work to do.
All right, let's see what questions we might have had come in that for y'all to answer. So just give me a minute to kind of read through a couple of these. All right. So Brian says, not our Brian, but Brian, our attendee, says he finds it troubling that the relative ease that hospitals sign MA contracts where the premium for doing so is not necessarily beneficial to the health system above and beyond traditional Medicare rules, which were required in the absence of the contract anyway. The loss of leverage in the appeals process may obviate any incentives to patients and/or health systems.
Is there a question there? We agree with you, Brian. Yeah, we agree with you, Brian.
We agree with you. Okay. What about, Kelly says, what about the hospitalist rights as they pertain to docs? Oftentimes we have commercial insurance docs that virtually steamroll our hospital docs by citing that they can use their clinical judgment and fall away from nationally recognized evidence-based criteria. The other thing they do is call to do the peer-to-peer when they know that our docs are busy. Like 3 times in a 15-minute span, then they say our docs were unreachable, and then it defers to paper appeals.
I think Kendall lets you.
There's a specific skill set that you mentioned. The hospitalist needs to be coached in how to deal with a peer-to-peer. Quite often, we'll see peer-to-peers that were done, and the insurer will take note that, for example, the hospitalist agreed with the insurer's interpretation of MCG, and they use that as the basis to uphold the appeal. So there are specific skill sets and tricks to be known. One of the biggest, I would say, is never agree with the medical director at the end of the conversation. Just say we'll agree to disagree. As to calling 3 times in 10 minutes and saying that was a good faith effort to reach the attending or a hospitalist bill, is that reasonable? Or that's often, I think, going to be defined contractually or under their policy manual. Is something they can or can't.
That's something that seems unreasonable to me, but that's something that's important to just keep in mind, is that every state in the United States requires that contracts be followed in what's called a good faith manner, meaning that you always have an argument. If you feel that their following of the contract is not being done fairly, that they're acting in a manner that shows bad faith, that's an argument you can use. It's not always going to be the strongest argument, but it's always there. You can always say, in this situation, because of these facts, you are acting unfairly. And that's a valid right you have under every contract.
Okay, good. Okay, have you seen a change in overturn rates objectively since utilizing a clinical legal approach? So do you want to talk a little bit about some of the results we've seen from the clinical legal approach?
Yeah,
you guys have seen?
I can speak anecdotally. As far as hard numbers, I don't have any off the top of my head. We have, for example, been successful in getting closed upheld claims going back 2 to 3 years, opened and overturned successfully and paid at 100%. These were claims that were dead and buried based on repeated clinical appeals, where we bought in legal arguments and contractual arguments, bought a State Department of Insurance, and the insurer suddenly agreed to find their wallet and pay the claim and called it a quote misunderstanding. So from that standpoint, things that were dead and buried, we've been able to resurrect. I do see fewer and fewer appeals coming back upheld with clinical legal arguments on them than I do see coming back with just pure clinical arguments. So from my standpoint, watching and seeing what we're doing, what's going out the door, what's coming back, those that tend to come back are letters that have just gone out with a pure clinical argument. We're seeing, I think, fewer and fewer of them that are coming back denied again when we've telegraphed our intentions and inserted a legal argument into them. So I think there's, we're really starting to see the payoff from some of this now.
Yeah. So our clinical legal unit and our partnership between the two languages, if you want to call it, we call it the hamburger and the bun, where the hamburger is the clinical information, the bun is all the legal protections on top and bottom of it, has really only been in place for about 18 months. But we are very, very encouraged by the results and quite surprised by some of the leverage the departments of insurance have exercised on some of these commercial payers in 4 or 5 of the states we deal with. So it's the momentum is growing. It works for us. We've baked it in there now, and we intend to continue it. And so because again, we were seeing just ridiculously upheld appeals as if they had never looked at the case. And so you have to get a little stronger. You have to, as Emerald says, bam, you got to add some pepper and follow through with it and follow through. So we're encouraged by the results.
When you're consistently getting appeals back on patients that are intubated in the ICU on life support and saying that the care could have safely been provided in an observation or outpatient setting, you know that the universe has just completely gone upside down. You've got something else. And I'm not making that up. We were starting to see those letters with some regularity. And both Denise and I have a desktop folder of just things that are earmarked that you just wouldn't believe. I mean, like, I don't mind, can you believe they did it? But so yeah, the universe has changed and times have changed, and I think the appeal specialist has to change with it. And this is a format that's here to stay and can only empower what you're doing.
Okay, Brian, not our Brian. Brian, our attendee, says, most contracts require that you fully exhaust internal dispute resolution pathways between contracted providers and payers. How do you avoid counterclaims that you have not fully pursued this pathway? But I think you said, Brian, we do pursue sometimes you do pursue the internal pathway, or sometimes you have to exhaust it before you go to external review, right?
That's a given. You really have to exhaust every internal grievance right that is available to you before you can move to that next level. And so I'll say it before, script it out. Okay, you got to hit the mark on the script before you can get to that independent review. It's like and when we go back to the ALJ and our experience there, you couldn't jump from the RAC to the ALJ. You had to go through, and let me tell you something. Our methodology was, we want to get to the ALJ as fast as we can. And so we don't care about level 1, level 2. We know they're going to rubber stamp it. And so we know we're going to get a much fairer shake at the ALJ. Like, I don't know, 8% overturned at level 1 in the RAC program, maybe 14% level 2. We were at 90% when we got to the ALJ. And so we're just carrying that forward. But you have to exhaust those internal grievances that are in the clinical or in their provider manuals before you can do anything else. Some of them might include an informal mediation or conference with the payer before you go to dispute resolution or external review. But any contract without external review rights is a bad contract, and I would suggest you avoid them and bring it up to whoever didn't put that in there.
But at the same time, from day one in appeal level one, we bake the language in, telegraphing what's going to happen if this isn't overturned.
Right.
So it's not a surprise to the insurer when URAC, NCQA, or the state insurance commissioner calls them up and says, what's going on between this hospital and your medical review department? We're getting some complaints here. They're put on notice. And I think, I can actually tell you that for certain hospitals that are doing this regularly, informing the insurers that if fair consideration isn't given to the appeal, the State Department of Insurance is going to be aware that when the state DOI starts to see a regular pattern of complaints, that the insurer is going to start to worry about investigations and fallout down the road. And you're much more likely to get a fair shake initially when they recognize that you're a hospital that is going to go all the way, and they can't keep doing these ridiculous upholds that seem to be becoming the norm for a lot of payers right now.
You got to tell them you mean business. Yeah.
Yeah, and you have to keep, and both Brian and Kendall alluded to this, when you do that internal process, just make sure you keep good records. Because when you get to the higher level, if they can plausibly make the argument, particularly if they pay expensive attorneys, if they can plausibly make the argument that you didn't follow all the steps, they will try to do that. But if you kept good records and you followed the process, that's an easy argument to counter. But you always have to make sure that you follow the steps and that you have records that you followed all the steps.
Right.
Okay, good.
Keep the data.
Okay. Donna asked, I think that's a good question. I find the question about external review interesting. We do not always have the option presented to us in our appeal determination letters, primarily Blue Cross Illinois. It seems like the out-of-state plans do not offer the external review.
Patients' rights.
That doesn't sound right.
Patients' rights.
Well, you still have to go back to, there's whether or not the home plan has external review rights. Remember, you're not contracted with the home plan, but if you're really having that managed by Blue Cross and Blue Shield of Illinois, I would find it really unusual that there is not some dispute resolution clause in that agreement. So external review doesn't necessarily just mean an independent review organization, but it can mean dispute resolution via mediation or arbitration. It would be really unusual for Anthem not to have that, or one of the other Blues plans. But Bill, this is an interesting question that Donna brings up, is how that interacts with the home plan. It probably remains to be seen, and because it's all we hear about: home plan, and
right.
Denied it. So
yeah, when dealing with Blue Cross, the fact that you interact with foreign plans, and by that I mean plans that are outside of the state where you're located, that's always a complication, because the local Blue Cross can always say, well, it wasn't our decision, it's not us,
sure.
we just passed it along. But then they often include in their letters, when they say these are your next appeal rights, they often reference their own policies, their local policies about that, not the foreign plans policies. So it does get more complicated when you're dealing with them. You have to you really have to be careful about what you can challenge in the local plan, and what you basically would have to challenge the foreign plan basically on their home turf about. And that can be done. We've actually taken challenges outside of local states to the foreign plans like Department of Insurance and gotten results. But that is something where if you have the resources, you have to take the time and say, where is this plan from? is that plan required by its state to provide external review? If it is it required to tell you that that's an option? Because those are not the same thing, and every state has different laws.
Yeah, I think a part of that question was we weren't told that we have an external review right. And
Right.
so it has to be incumbent upon us, the provider, to look at that contract and to make sure if I have dispute resolution with Blue Cross and Blue Shield of Illinois, I'm going to invoke it or figure out because, I don't think they're going to volunteer. Oh, you have another level you haven't thought about. If they're required to do that, great. But I don't think that a straight Blue Cross and Blue Shield plan is because they'll all tell you this is your final level of appeal. Well, it is for internal grievance, okay, but it's not when you say, oh, okay, I do have additional rights. When we agree to disagree, that's what dispute resolution is all about.
Okay. So we have Phil Baker actually gave us a little information in the questions area. So Phil, thank you for being on today and
all right.
For providing
Phil.
sharing some information. So I'm going to read this to you all, and then we may have time for maybe one more question. There's a lot of questions in the questions area, and that's wonderful. We will do our best to try to answer those in some form or fashion going forward. So anyway, Phil Baker says he wanted to tell us about the response he got from CMS. And several of the plans have wised up to the CMS 1696 form so that the plans are rejecting the appeals. And the original question was as follows. We're being told by WellCare that we are not allowed to file a beneficiary appeal using the CMS form 1696 for inpatient status, stating that under CMS guidance, PAR providers do not have appeal rights for claim denials. But we should be able to access the beneficiary's rights using this form, as they are denying the beneficiary the right to a full inpatient admission with rights such as ability to appeal the discharge. Could you provide guidance on that situation? And Phil says the response is as follows. In general, Medicare health plan enrollees are permitted to appoint providers, including contract network providers, family members, friends, or others representatives under the 42 CFR administrative appeals process.
Yeah. So don't forget, your payers will obfuscate. They will they'll trample on your rights, and they may not include things they need to include. So it's really important for every hospital to take it personally that that payer, if you try to use a generic payer authorized representative form and they reject it, well, fine. Just get their own representative form and have it signed. And so it's got to happen in the industry. It just has to happen. Just from the way that ERISA is moving, which is really all about beneficiaries' rights, and the way that Medicare Advantage is moving, one and done, unless you're appealing on behalf of the patient. If you appeal on behalf of the patient as a Medicare Advantage plan, you get to go all the way to the ALJ. It's the same process as if it were traditional Medicare. So, Denise, another question?
One more quick question, and then we're going to wrap it up. Speaking of ERISA, how can you tell if a plan is protected by ERISA? Is it on the insurance card?
That's a good question.
Difficult. Well, no. Here's what I can tell you. You take a look at these insurance cards, and there are networks and silent PPOs, and they're all mistaken. You have to get down to the point of identifying this is something that has to be fixed in the registration process. Early on, who's the employer, right? Almost every face sheet in a medical record has whether or not that patient has an employer or they're protected under a plan. But within your plan master, your insurance master, you should designate whether or not this is in fact an employer-based plan. It's important to get down to that level. Right now, I see most insurance masters simply say commercial. And I'm like, that's not enough. That's not enough. But pretty soon, 70% of all commercial plans, which is not a marketplace plan, will in fact be employer-based. However, it's not easy to figure it out from the card. It's just not. And until something changes, I think it's still going to be difficult to identify unless you make that part of your registration process.
Okay. Thanks, everyone, for joining us today. We're at our 90-minute limit. Warm springtime wishes to everyone.
Happy spring.
Please contact us if we can assist you in any way. Sign up for our next webinar at www.ahdam.org. Complete the survey, and we'll see you in May for our next one.
Thanks everybody.
Everyone.
Have a great one.
Thank you. Have a good one. Bye.